Well, thank you, Jessica. I want to focus on the implications of King versus Burwell for statutory interpretation and for actually one other pending Affordable Care Act case of potential importance. King's greatest jurisprudential importance probably lies not with interpreting the ACA, but rather in administrative law and statutory interpretation more generally. As Jessica pointed out, the majority opinion did not rely on Chevron deference to achieve its result. It did not say the statute's ambiguous and therefore a reasonable IRS interpretation of the statute prevails. On the contrary, the court pinged FDA versus Brown and Williamson Tobacco Corporation to hold that in some cases, Chevron deference is inappropriate. It's inappropriate even whereas here, the court finds initial review to leave much uncertain about the meaning of the statute. No concurrences on this point. Everyone rejected Chevron. Rather, citing no less than Marbury versus Madison, the 6-member majority asserted that it was emphatically the province of the Judicial Department to say what the law of the ACA is, and to do so using more than reductionist sentence parsing. The court forewent announcing a precise test to determine when Chevron deference should not be used. It instead made the base issue one of congressional intent, and 5 factors were used to discern intent. 1, the subject matter of the dispute is among the Act's key reforms. 2, the key reform involves billions of dollars in spending each year and affects the pricing of health insurance for millions of people. 3, the interpretation of the statute is of deep economic and political significance. 4, the sought interpretation of the statute is central to the statutory scheme. And 5, the agency promulgating the rules, here the IRS, has no expertise in crafting policy on the matter in question. Now, what we don't know yet is whether this is some one-off standard that will never be met again. How often, after all, does Congress assign an agency rulemaking authority in which that agency has no background? How often will a case truly be central to a landmark piece of legislation affecting 1/6 of the economy? On the other hand, King may become as cited as Chevron itself, which is actually one of the most cited cases in Supreme Court history. Lots of statutory interpretation questions involve key reforms. Many statutory interpretations involve billions of dollars and affect the price of important goods and services. And some might attribute deep economic and political significance to all sorts of legislation. We just don't have enough data points yet to know where the divide is. But if you're a lawyer, you should be probing in your cases either to get on the King side of the boundary or make sure you have argument defenses in place when the other side seeks to emigrate from Chevron land. With respect to statutory interpretation, King enables all sorts of sophisticated and sophistic arguments and frees practitioners from slavish devotion to maxim, counter-maxim trench warfare that often decides these questions. As Jessica Mantell pointed out, King acknowledges that legislation is frankly often sausage, full of process errors, incoherence, and human error. And too often we attribute false meaning to an accident. And there appears to be strong empirical evidence that much as we might wish to the contrary, doing so does not invariably get legislatures to clean up their drafting act, not even on landmark legislation. And the cost of false pattern finding could, as here, be significant. Instead, the Roberts opinion proceeds that courts should combine statutory language and some background in economic reality to attempt to divine broader purposes of the legislation. And I think Professor Mantell pointed out exactly what that was. But we see in the Scalia dissent and elsewhere some of the troubles created by Roberts' anti-formalism. Which of the several purposes of the ACA are we to consider? One is the purpose of getting working insurance markets, but the other is to get states to assume responsibility for insurance by threatening them with likely dysfunctional insurance markets in the event they fail to do so. So what does this mean for you? I think it means that your ability to narrate a credible policy story in favor of your interpretation becomes more important post-King, as does your ability to find great experts, like law professors, who can testify about how this or that purpose will truly be threatened by one or another interpretation of the statute. Before King, I think many judges would have considerable trepidation about abandoning the fiction that every word of the statute was actually carefully thought through. And after King, there may still be judges who are unwilling to embark, but at least you won't be laughed at anymore when you use reality to help select the most favorable of the many meanings that words alone might provide. Now, those of you with regulatory practices should not abandon efforts after King to obtain favorable agency rulings. Having the agency side with you seldom hurts, even after King. But also consider whether King would have come out the same way in some imaginary world where the IRS decided that middle-class voters, those would not receive subsidies if their states did not establish their own exchanges. This would be hurting the bread and butter of many state legislatures. And what might well have happened under those circumstances is that most states, except the massive resistance ones, would have succumbed to the threat just as they do with highway funds and established their own exchanges. There would be no pride, as there might be today, in holding out. And the twin goals of the ACA, federalism and healthcare coverage, would both have been served. And now consider what would happen if some state then wanted to be relieved of the burden and sought a declaratory judgment that its citizens were entitled to subsidies even if the state delegated its exchange to the federal government. I think under those circumstances, the court might well say that reinterpretation of the requirement that an exchange be established by the state might hurt the federal government's goal of getting states to take responsibility for their insurance markets, and it wouldn't substantially advance the goals of the ACA. In other words, even though there is less formal Chevron deference post-King, there is still Chevron reliance, there is still Chevron inertia as society adapts to the agency's initial determination of rules. House versus Burwell. There's another case coming down the pike, House of Representatives versus Burwell, which has the potential to wound Obamacare greatly. And not just in some states, which was the case with King, in every single state. It's about, for those of you scoring at home, 42 U.S.C. section 18072 C3A, payment of the cost-sharing subsidies that convert silver policies for lower-income purchasers into policies whose cost-sharing requirements more closely resemble the more generous gold and platinum plans. The case is now sitting in the District Court for the District of Columbia, but will surely get at least to the D.C. Court of Appeals, and the logic of King versus Burwell has some relevance. The basic issue in this case arises from the fact that Congress never actually appropriated any money to pay for the cost-sharing subsidies contained in the ACA. And yet the Obama administration is paying insurance companies anyway out of an account that is supposed to be dedicated to tax refunds for taxpayers. And these payments are definitely not tax refunds or advances on tax refunds. And so, under various federal provisions, those making the payments could actually be criminally liable. And by the way, won't that be a fun action for President Cruz's Attorney General to pursue against former members of the Obama administration? And shareholders, take note. Insurers who have been receiving these large payments, which would be termed embezzled funds, might have to refund the money. So what's the Obama administration's defense? One is that this dispute is non-justiciable, and that may well prevail. Beyond that, however, its argument may well depend on King versus Burwell. The idea is that without these cost-sharing subsidies, the policies would be less attractive, and at least one King-approved purpose of the ACA would be in jeopardy. Would Congress really have intended to pass a statute? I can hear some lawyer channeling Robert's King opinion say that so impinged on a central goal. And since, through an argument I would be thrilled to elaborate on during question and answers, it turns out that money spent on cost sharing will save the government tax refunds it would otherwise probably have to make, why not just let the government dip into the tax refund account to compensate for Congress's probably inadvertent failure to formally appropriate funds? Now, before King versus Burwell, I would have said that this was sort of the sort of loser sophistry that only the graduates of our finest law schools could concoct. Accepting the argument would subvert the appropriation process by letting the executive branch pay for any program for the poor enacted by Congress, but for which funds were not appropriated on grounds that doing so reduces the amount the Treasury might owe in the Earned Income Tax Credit. Moreover, if you do the math, the amount the feds pay differs using this backdoor mechanism. And anyway, it's a different story. But channel Roberts in King. The ACA is important. Read it in context and with an understanding of its purposes. Would Congress really have wanted to make the policies less attractive by walling off money that would ultimately be used to support the program anyway? And if the House ever gets over the standing argument, the justiciability argument, we may find out whether King versus Burwell can save the Obama administration in House versus Burwell. I don't think it will. Chief Justice Roberts may yet have the last laugh. But as the outcome in King emphasizes, you never know.